And we're back. Welcome back, everyone. Attorney Craig Steger here, practicing in Wisconsin, Minnesota, and Iowa. A insurance company, USAA, which I'm not going to tell you what that's actually stands for because I don't remember, but they got whacked with a $100 million punitive bad faith verdict the other day. And so I wanted to talk a little bit about that, explain what went so wrong for that insurance company. So this happened out in Las Vegas, I believe, so in Nevada, and started out pretty, I would say, uneventful from the standpoint of litigation and lawsuits. And the plaintiff in that case, so the guy sort of whose injuries are at the heart of that case, his name is Timothy Kuhn, and he was rear-ended in traffic in 2018. So he was driving a BMW sedan, and he was rear-ended by a pickup truck. And uh, Kuhn himself um, was insured by USAA. So USAA insures people and family members who are or were in the military. I don't think it's a military insurance company per se, but I think you have to have some military um, experience in the family in order for you to be eligible for this auto insurance coverage. So Timothy, the plaintiff, was insured with USAA insurance, and the driver that ran into him, that rear-ended him, I don't know if we have the name of his insurance company or not, but so Timothy had sort of the standard, if you will, concussion type injuries following that. He had neck and back injuries, and then he had ongoing memory loss, loss of focus, headaches, which he argued, or his attorneys argued, was evidence of a brain injury, maybe a mild traumatic brain injury. And the driver that ran into him had insurance policy limits of $50,000. So $50,000 is how much the other driver had in insurance. And then Timothy Kuhn had $250,000 in insurance limits on his policy. So that would be underinsured coverage that he had. What that probably means is he had a policy of $250,000 of liability, which also probably had $250,000 of underinsured coverage. And depending on how it works out, depending on what's permissible in your state, that 250,000 may go on top of whatever the other driver's liability insurance limits are, or possibly gets reduced by that. So irrespective, he had up to, let's say, 200 to 250,000 in additional coverage under his policy, or a total of 250 to $300,000 in total coverage between the insurance that the other driver had and the insurance that he had. So the other driver's insurance company paid its $50,000 policy limits to Mr. Kuhn, to his attorneys, to get out of the case. And in exchange for that, probably got some sort of a release agreement with them. And so then once he got the $50,000 policy limits from the other driver, which is normal, that's kind of how it works, he then made a demand on his insurance company. So then he demanded from USAA its policy limits of $250,000. And USAA got itself into some trouble because, first of all, it sounds like they disputed or tried to dispute whether he may have caused the crash. Maybe he stopped suddenly. Maybe that was going to be their defense. Like I said, he was rear-ended. He was in traffic, and he was rear-ended, but that didn't stop USAA from trying to argue that he may have actually been the cause of the crash. And then, as is typical, they challenged the extent of his injuries. They challenged the idea that he had any head injury, in part because sounds like he made a pretty fast recovery. All things, by all appearances, made a um, quick recovery. But with which is common with head injuries is it's not always obvious when you look at someone that they have symptoms of a traumatic brain injury, mild traumatic brain injury, concussion, those kinds of symptoms. They often appear fairly normal, but inside they're dealing with some things that are really, really bothersome. And unfortunately, these kinds of injuries can sometimes never really resolve. And even though they are not, let's say, necessarily interfering with your ability to go about your life and think and remember, they do slow it down and interfere with it. And if that's going to happen for the rest of your life, that can be, that can be a substantial claim. So he demanded the $250,000 um, underinsured policy limits, and USAA offered him $10,000 and refused to negotiate from that. So in USAA's mind, he was going to be getting a total of $60,000. So they were offering him $10,000, and the prior $50,000 he had gotten from the U.S. From the liability carrier for the, we call it the tort fees, or the person who caused the crash, totals $60,000, and they apparently refused to come off of that until just on the eve of trial. So just on the eve of trial, probably thinking that he would fold. They said, "Oh, here's our $250,000." So they paid tried to pay their $250,000 liability limits. They're like, "Hey, this is all we've got. We're gonna pay you the policy limits. The case is gonna go away, right?" That's what the insurance company was hoping. Not quite. And at that point in time, and so this is what we call setting an insurance company up for bad faith, and this would be what we call first party bad faith, right? Because this was his insurance company, so he's the one that was insured by USAA. It's not like he's making demands on someone else's insurance company, as is usually the case. He's making demands on his own insurance company, and he's asking his own insurance company to pay benefits that he himself secured and paid for, right? So, and because of that, USAA, as his insurance company, had certain duties to him, duties to fairly and honestly um, pay out claims, pay out coverage to him as they're insured. They're actually ethically required to do so, and probably under the terms of their own insurance policy, required to do what is sort of fair and just to him, and not play hardball, if you want to call it that. Well, that's more or less what USAA did in that case. So they tried at the last minute to get him to take the $250,000 that he had been demanding well before trial. And his attorney says, we're going to go to trial anyway. And they went to trial. And by the way, for any attorneys that are listening, the whole trial was recorded from start to finish, actually two phases. Because, like I said, I believe they would have had the initial phase to determine damages, and then a second trial, which is normal in punitive damage cases or bad faith cases, a second trial on that. But the jury awarded him $14 million in compensatory damages. So here you have a case where the insurance company more or less valued his claim at $60,000. So 50,000 in liability limits from the tortfeasor, plus the 10,000 that they were willing to offer up until the eve of trial. And then he gets a $14 million damage award. That's based on what the jury thought that he deserved for his injuries in that crash. And so then the next phase of the case, I'm not sure how far apart if these were in fact in front of the same jury or not. I don't know how they do things in Nevada, but they then awarded $100 million in punitive damages against USAA, finding that it acted in bad faith. For sure, by only offering him $10,000 on a case that obviously had much greater value than that, or even when it offered it had to offer the $250,000. Like if the insurance company had early on in the case, when a demand had been made upon the insurance company for the $250,000, the insurance company could have paid that, and most likely would have been protected from all this because they would have fulfilled their duties under the contract. They would have paid the $250,000 that they had contractually agreed to pay, and they could have avoided all this. It's not like they were going to be on the hook for 14 million or $100 million from the beginning. No, all the insurance company had to do was to look at his case, and probably if they'd have offered him more than $10,000 but less than his policy limits, even then there's probably a decent chance the case would have resolved. But the insurance company took a very, very hard line on this, and then when it realized it was out of options and trial was coming, then they tried to basically save the day by paying the 300 or the $250,000 in limits, in the plaintiff's attorneys in that case courageously, I would say, stood their ground and says, no, thank you very much for the $250,000, but now you're going to have to write a much bigger check. And that's what happened in this case. So that's bad faith. So bad faith is where insurance companies put their own profits, their own financial interest before the interest of their insured. And there's really kind of two key ways that you can have bad faith claims. Number one, you can have, like I said, what in this case, which is a first party claim, where the insurance company unreasonably refuses to pay benefits, either uninsured or underinsured, is probably the most common type of bad faith claim, at least in auto accidents. So you have that, and then second of all, you can have a situation where let's say that the other driver's insurance company had refused to pay his $50,000 policy limits. So the plaintiff's lawyer had made a demand for the $50,000 policy limits, and the other insurance company says, no, we're going to give you $10,000. We're not going to pay $50,000. We're not going to offer those limits up and get a release for our insured, the other driver, and protect them from further liability. And that's probably the more common way that bad faith comes up. And then let's say this case goes on to trial, and suddenly this person has a verdict of $14 million against the other driver. The other driver's looking around. He's like, well, what the heck happened here? They offered to take $50,000. They would have let me out of the case entirely. You guys chose not to do that, and now I owe $14 million. Explain that one to me. And so then what happens typically is that person then sues their own insurance company, again, first party, but they sue their insurance company for not protecting their insured from that liability claim when they had a chance. And then, not to get too complicated, sometimes they'll assign that claim or whatever to the plaintiff. Ultimately, it's going to be the plaintiff that ends up with the money, the person who is injured. but it's bad faith by the insurance companies for unreasonably refusing to pay damages that have been, fairly established, fairly proven by the evidence. And so that's bad faith. That's how punitive damages can come up. That is, that's like I said, a very new verdict. I think that came out. Was it just within the last month or so? It came out. It came out in, it looks like, early February of 2025. Undoubtedly, an insurance company will appeal that, and possibly they will get that overturned. Sometimes you can appeal the basis for punitive damages in the first place, or sometimes challenge the amount of it and say, well, $100 million is excessive. So I will kind of monitor that one. I'm guessing we haven't heard the last of that case, but yeah, $100 million plus the $14 million compensatory damages is a big spanking to that insurance company. So if anyone has any questions about that after the fact, feel free to leave a comment or just send me an email. Go down to the uh, description. There's a link there. You can get a hold of me. I'll be happy to try and help you if I can. Otherwise, appreciate everyone watching. I should be back here again tomorrow morning, as I am every morning live streaming. And I hope everyone has a great day. And until next time, everyone, have a good one.